Welcome back to the Texas Business Court Insider. I'm Andrew Price.
And I'm Rachel Roosth. Today we're diving into two recent Texas Business Court decisions in which the court considered the internal affairs of LLCs. Those two cases are Quintero v. Urban Infra Construction and Crane v. Norton. There was a common theme we noticed in these two opinions, which is that the court rejected the parties' attempts to avoid the plain language of the governing standards, whether those standards were from statutes or the parties' contracts. Andrew, with that theme in mind, can you tell us about the Quintero case?
Absolutely. In Quintero, the First Division applied the plain language of the Texas Business Organizations Code in interpreting allegations related to membership in an LLC. Essentially, the question in Quintero was who is a member and whether or not Quintero was, in fact, a member of the LLC. And the court rejected Quintero's claim that he was a member in the defendant LLC.
So why was that? Why did Quintero think he was a member to begin with?
Well, Quintero claimed that he had entered into an agreement to form a partnership to perform construction services, basically to be equal owners in a business and share equally in the profits. He believed he had formed a partnership, but the business had actually been organized as an LLC pursuant to a written LLC agreement. He argued both that he had a partnership and that he was an intended member of this LLC.
Andrew, how did the court analyze and rely on the Texas Business Organizations Code when it was trying to resolve this issue?
Well, this issue is largely addressed by the Texas Business Organizations Code, specifically Section 101.103. And the court examined the statutory pathways laid out in that section to becoming a member in an LLC. And that statute's relatively clear. A person becomes a member in an LLC in one of three ways. One, being named an initial member in the certificate of formation. Two, being admitted as a member in connection with the formation of the LLC. Or three, being admitted with all members' consent after formation.
Andrew, from what you said already, it sounds like Quintero did not follow any of those pathways. Is that right?
He did not, which was a big problem. And the court found that Quintero was not listed as a member in the certificate of formation. And the court also noted that Quintero was arguing he was a partner in a partnership, not that he had been admitted as a member in the LLC. And with regard to the third pathway in the statute, Quintero wasn't even trying to argue that he had been added after formation, so that didn't apply either.
Did Quintero have any other arguments for why he might have been a member in this LLC?
Right. Our listeners are probably wondering, well, so what was this case about? He did. He provided the court with the LLC's balance sheet, which showed about $40,000 in owner equity attributable to owner equity, and he provided testimony that he had contributed $10,000 to the LLC. And it was undisputed that some of that line item, the $40,000 of owner's equity, included the $10K. But the parties disputed whether or not that had been a membership contribution or, as the defense was arguing, just a loan by Quintero to the LLC.
Okay, but Andrew, why wasn't that sufficient to raise a fact issue that could preclude summary judgment?
Well, the court simply determined that the balance sheet was not sufficient to raise a genuine issue of material fact as to whether the money was a membership contribution. And why was that? It's because case law required testimony evidencing a contribution and that it has to be corroborated by written evidence or records of the company demonstrating the contribution. And the court noted that the list of company records that suffice in the code does not include balance sheets.
Well, isn't a balance sheet written evidence?
Well, a balance sheet is written evidence, but the court noted that the BizOrg code contains a list of specific corporate records, and a balance sheet isn't on the list.
Interesting. So is that the only reason the court rejected Quintero's arguments about the balance sheet?
No, not really. The court also turned to the Business Organizations Code for additional guidance and determined that the code does not require a capital contribution at all for membership in an LLC. So the court went on and held that membership in an LLC is not contingent upon or proven by evidence of a capital contribution to the company.
Okay, so that's an important point. It's not enough to show you contributed money to an LLC. That in itself doesn't make you a member. You also have to follow the statutory formalities too.
Exactly. So relying on the BizOrg code and the language of the statute, the court rejected all of Quintero's claims that he was a member in the LLC. Rachel, the other case we wanted to cover today with a similar thematic is the Crane case that talks about internal affairs of an LLC and a buy-sell agreement. Tell us a little bit about what happened in that case.
Sure. Crane v. Northern was another dispute related to LLCs, but in that case, there was no dispute about who the members were. There were two founders, Crane and Northern. They were equal owners of 3 LLCs. And in this lawsuit, as relevant to our discussion, Crane alleged that Northern breached his fiduciary duties to Crane and the 3 LLCs. And Northern sought specific performance requiring Crane to sell his membership interests to Northern.
Why did Northern think a forced sale by Crane was possible?
Well, Northern was relying on a buy-sell option clause in the LLC agreements. He had triggered these clauses by providing the required written notice to Crane. And the next step under these clauses was that Crane had to elect within 30 days whether to buy Northern's interest or whether to sell his own interest to Northern.
And what did Crane do?
Well, he didn't choose either option. Instead, he just did not make an election within those 30 days. And that really mattered here because under the buy-sell option clauses, he was conclusively deemed to have elected a sale of his interest. But Crane refused to do so. He refused to transfer his interest to Northern.
So what was the reason why Crane had refused? And I assume he tried to challenge the buy-sell provision?
He did. He challenged the validity of the company agreements, and he alleged that Northern's prior breaches and unclean hands precluded enforcement of the buy-sell option clauses. But the court rejected these arguments because it found that Crane had failed to produce summary judgment evidence to support the arguments.
And I assume the court interpreted the buy-sell provision. How did it go about doing that?
Yes, it did. The court found the language of the buy-sell option clause to be very clear. So it said it was enforcing the plain language of the agreement. It said the language was definite, unwavering, and agreed by both parties, and that the language left little room for interpretation. Then as to the deemed election portion of that clause, the court also stated that contractual buy-sell mechanisms must be exercised or timely challenged in the manner the agreement prescribes.
And was there any indication or evidence put forward by Crane that he had in fact challenged the option within the required time period?
No, there was nothing in the court's opinion suggesting that Crane challenged the buy-sell option during that 30-day window.
So you mentioned that there were allegations of unclean hands. Does that mean that even if the court had found Northern had actually had unclean hands or had engaged in some sort of prior material breach, that Crane still would have been found to and deemed to have elected to sell?
I don't know if we can go that far based on the court's opinion. It's possible that the court would have made that determination, but that is not really the scenario the court was considering. So what we can say is that under this particular fact pattern, where there was no summary judgment evidence of unclean hands or of a prior material breach, the court enforced the deemed election clause as written.
And when you say the court enforced it, how did the court go about enforcing the provision?
The court required Crane to abide by the consequences of that clause. So the court ordered Crane to assign his interests to Northern, and the assignment was made retroactive. So the effective date was the date required per the buy-sell options clause. And I'd also note that the court awarded Northern his requested attorney's fees for his claim that Crane breached the contract by refusing to transfer his interest.
Rachel, what do you think that both the Crane v. Northern case and the Quintero case tell us about how to advise clients on LLC formation and governance issues?
I think there are a few takeaways. One is that if you want to be an owner of a business, you are best served by following the Texas Business Organizations Code and adhering to any formal steps required to evidence your ownership interest. And another takeaway is that if you are relying on extra contractual evidence to avoid contract language, the Texas Business Court will hold you to your proof. And so you need to have your admissible summary judgment evidence ready to go because this court moves pretty quickly.
That all makes a lot of sense, Rachel. I think these cases are also great examples of the business court doing exactly what it was designed to do and I think is hoping to do, and that's providing clear, predictable outcomes in business disputes by applying the law and the agreements that are put before it exactly as they're written.
I agree, Andrew. Well, to our viewers, thank you for joining us today on the Texas Business Court Insider. We will be back soon with more analysis of the latest developments from the court. Don't forget to subscribe below so that you are notified when we post new videos.
And be sure to check out our Texas Business Court Insider Hub, where you can find articles about developments in the Texas Business Court and beyond. We'll see you next time.